And are you hitting record, Sue, or do you want me to?
Looks like we're recording now.
Okay, you got it. All right. We'll give folks a chance to get in this morning, and we'll get started in just a minute or two. Oh, I don't want to do that. Patrick, we were talking about musical performances. We've had a few performances. We're very close to Overland College in our Ohio market, in the Northern Ohio market. And we've had a couple of groups of students who have sort of pre-recorded like live sessions. And it's really interesting to watch them when we are doing these events, because they often haven't seen each other for a long period of time, and then they're watching their performances. It's really been kind of interesting to watch them. They're such talented musicians, and to watch their expressions and things. You can see when they think, oh, they messed up on something,
Yeah.
or they're really excited about how it all came together, or kind of reminiscing about that time. And I think the first one we did, they hadn't seen each other in quite some time, and talking about the possibility of getting back together for live performances and things like that. I would imagine if you're a musical performer, the virtual isn't quite as exciting as being in person.
No, I wouldn't imagine so. The engagement and interaction.
Yeah. Well, hopefully we'll get to see live music again someday soon.
Yeah, hopefully.
All right. Well, as we give people maybe just another minute to get in, and then we'll go ahead and get started.
Great.
All right. Why don't we go ahead and get started, and folks will join us. So thank you all for joining us today for our coffee hour. Hard to believe already that it's April. Today's topic is, what is the 14th Amendment? And I think we're all about to learn in great detail what the 14th Amendment is all about. And we're very excited today to have Patrick Wohlfarth, who's our presenter and speaker for our coffee hour this morning. Patrick is the Associate Professor and Co-Director of Graduate Studies and Placement in the Department of Government and Politics at the University of Maryland, College Park. He has his PhD in political science, which he got at the University of North Carolina on Chapel Hill. And he's a postdoctoral fellow in the Department of Political Science and Center for Empirical Research in the Law at Washington University in St. Louis. So he's no sloucher. We got someone with a little brains on this today for sure. And he is also the co-author of 2 books. I said if he didn't tell you, I would. I think it's an accomplishment to have published books and have all the work that I'm sure has gone into this. And the titles are The Conscientious Justice, How Supreme Court Justices' Personalities Influence the Law, the High Court, and the Constitution, and U.S. Supreme Court Opinions and Their Audiences. So, Patrick, I am so grateful to have you here with us today and appreciate you taking the time. I am going to stop sharing my screen, and we can ignore that October. And I am going to turn this presentation over to you. I do want to just let the audience know that the rest of us will turn off our cameras, and Patrick's will still be on. So if you go to the top right, at least it's the top right in my camera or on my screen, you'll see the option for speaker view. And if you go to speaker view, then you'll only see him and not the rest of our tiles. And if you have any questions, if you'll type those in the question and answer section, we'll interject those questions as appropriate, but we'll have plenty of time at the end for folks to ask questions and for you to ask Patrick for more information. So I'm gonna turn it over to you, Patrick, and the rest of us are gonna be silent and invisible.
Well, thank you so much for having me. I really enjoy teaching. I really enjoy talking about the Constitution and the U.S. Supreme Court in particular. And so I'm glad that so many of you could join us this morning. And I look forward to interacting with you once I complete my presentation. And what I want to cover today is essentially a crash course overview of the 14th Amendment. And so I want to kind of cover four particular points, or my presentation will have kind of four particular parts. Number one, I want to give you a brief historical background behind the 14th Amendment, how it came to be, the political motivations behind the 14th Amendment, to provide a little context about the initial intent of this important part of the Constitution. And then secondly, I want to deconstruct the 14th Amendment for you, especially Section 1 of the 14th Amendment, which is the most important part of it. And so I want to talk about the four main clauses of Section 1 and talk a little bit about their meaning today, a little bit about how it's evolved over time. And then I want to conclude by drawing some connections with political issues and public policy today. So to touch on not only some important cases historically that have involved, important Supreme Court cases, that involved the 14th Amendment, but also some more recent political issues and policy debates in American politics, where the 14th Amendment is really central. So here's Section 1 of the 14th Amendment. Now, first, in terms of an initial context here, this was passed soon after the Civil War and was a response or part of the Reconstruction efforts of the Republican Party at the time. And so I want to focus most of our attention today on various parts of Section 1, which I've included the text here. And so as we'll talk about here soon, we can really think about the Section 1 as having four key clauses. Here, this is called the Citizenship Clause. Next, in the middle is the Privileges and Immunities Clause. And then third is the Due Process Clause. And then last, but certainly not least, is the Equal Protection Clause. So a little bit about the historical background of the 14th Amendment before we deconstruct it and talk about each of those clauses in more detail. First off, it's important to know that the 14th Amendment was passed as a way to try to protect the citizenship rights and codify the citizenship rights of former slaves. So in many ways, the 14th Amendment was the next step after the Civil Rights Act of 1866. And it was an attempt to kind of codify into the Constitution citizenship rights in a way that will be more durable and more difficult to change. So on one hand, it was addressing the limits of the 13th Amendment, or trying to extend the 13th Amendment, which abolished slavery, and seek to ensure that states would respect the citizenship rights of now former slaves. And so really the primary goal of the 14th Amendment was to set out to define national citizenship and protect these citizenship rights. I also want to highlight, though, again, just as a little background, that there's a lot of politics involved here, that to at least to some extent, the 14th Amendment was a strategic play by the Republican Party during Reconstruction. So if you know a little bit of post-Civil War Reconstruction history, the Republican Party at the time basically took control of the southern states after the Civil War. And so on one hand, while the 14th Amendment certainly was seeking to establish citizenship rights for former slaves, it was also a way to bring more supporters into the Republican Party and bring more perhaps political influence into the future. So where you can see this is in Section 2, in terms of how Section 2 of the 14th Amendment lays out an apportionment penalty, a representation penalty in Congress, if states did not respect the voting rights of of Blacks and former slaves. And of course, this should also be considered in tandem with the 15th Amendment. And then Section 5 gives Congress broad enforcement power to seek to enforce various principles and clauses from the 14th Amendment. And then also the Reconstruction Act of 1867 not only brought about military control of the South in Southern state legislatures after the Civil War, but it explicitly made readmission to the Union contingent on ratification of the 14th Amendment. So essentially, the 14th Amendment as a political tool was a way to not only ensure or try to ensure that former slaves would have citizenship rights, but then to do what it could to ensure that Southern states, as they rejoined the Union, would not infringe on those rights. And as we will see, of course, it wasn't entirely successful, and it took a long time before the federal government could start to make substantial progress on this. And so if we point to the limits of the 14th Amendment, especially as it pertains to ensuring the rights of citizenship, voting rights, et cetera, of Blacks and former slaves, excuse me, some of the limits include, first off, the 14th Amendment didn't really initiate any real economic or land reform. So while it set out these principles of citizenship rights, former slaves still didn't have property. They didn't have, it wasn't as easy for them to support themselves. But also politically, it's important to point out how soon after the 14th Amendment was passed, it wasn't long before Southern Democrats regained their political control. Okay, and this first started out in state legislatures. So by 1869, you have Southern Democrats reclaiming control of some state legislatures. And really, by 1877, all former Confederate states were no longer under the purview of the Republican Party's control. But it also spread to Congress as well. So as I've kind of noted here, Democrats regained control of the U.S. House in 1875. And then kind of what's often thought of as kind of the final nail in the coffin, so to speak, is the presidential election of 1876, which is infamous for being a disputed election with a disputed electoral college count between Rutherford B. Hayes and Samuel Tilden. And in a nutshell, Hayes came out the victor after a long process of Congress sorting out the disputed electoral college count and appointing a so-called electoral commission. But in the end, once Rutherford B. Hayes took occupation of the White House, essentially the Republican Party abandoned Reconstruction, and they simply didn't have much political power left anyway. And they didn't really have much more control over Southern state legislatures. And so in sum, while the 14th Amendment set out important principles to ensure the citizenship rights of Blacks and former slaves, it really was just a de jure citizenship inequality under the law, but not really de facto. And of course, this sets the table and the landscape for a long period of time until the mid-20th century. Civil Rights Act in 1964, Voting Rights Act in 1965, and further federal actions to try to move closer toward some degree of de facto citizenship equality for Blacks. So that's the historical background of the 14th Amendment, at least in a nutshell, given the time that we have today. Next, I want to pivot.
Patrick, can I interrupt you for one quick question related to that?
Certainly.
Jonathan's asking, in connection with the political aspects of the 14th Amendment, some people have argued that requiring the former Confederate states to ratify the amendment somehow fatally undermines the legitimacy of its ratification. What can be said in response to this argument?
I mean, I think that it's a plausible argument, and because it was forcing the Republican Party and the Union states I guess technically then former Union states at the time, were basically forcing it on the southern states. And so you certainly didn't have a groundswell of public opinion in the South in favor of the 14th Amendment. And those who would come to lead the southern states and have the political power in their state legislatures and what have you, and then later Congress, or disproportionately not in favor of the 14th Amendment. So really, I guess you could say that forcing the 14th Amendment and forcing ratification upon the southern states was just really a short-term measure. And because there was no significant political buy-in, that I guess we shouldn't be surprised that it didn't go very far in terms of ensuring de facto equality. Thank you for the question. So let's switch gears to talking about the four main clauses of the 14th Amendment. And I just want to give you an overview by identifying the particular text that we associate with these clauses, and a little bit about the current meaning and evolution of these clauses and how they function in society today. So number one is the citizenship clause. And this is arguably the most important clause, or at least, of course, the due process and equal protection clauses that we'll talk about shortly have been critically important throughout American history to ensure civil rights and equal treatment under the law. But it really the anchor of the 14th Amendment is this citizenship clause. And it's the anchor because it established that citizens of the United States are citizens of the US first. And that state citizenship basically is derivative of that. Whereas for a long time, American politics had this sense of dual citizenship, where people were citizens of the United States, but they were primarily, perhaps first, citizens of a state. And the kind of seminal or often cited case that kind of demonstrates this is Barron v. Baltimore in 1833. I won't go into all the details, but suffice it to say that this involved a dispute between a wharf owner in the city of Baltimore and the state and local government. And his issue was that his wharf sediment was collecting in his wharf, and it was becoming less useful to him, and his business suffered. And so he believed that he suffered unconstitutional takings such that his property was taken without just compensation. And so he sued and he lost. And he lost because the Supreme Court declared that the Bill of Rights and the various civil liberties in the Bill of Rights existed to protect citizens against the national government and not a state government. And that really just goes to emphasize and highlight this idea of a dual citizenship. And that as states at the time were very much in the idea that you were first a citizen of a state, or at least as equally a citizen of a state as you were a citizen of the United States, was really the prevailing view of the Constitution for a long time. Especially until the incorporation of the Bill of Rights, we'll talk about a little bit here shortly, later in the 20th century. So going back to the citizenship clause in particular, though, this was a first step in kind of reorienting or kind of clarifying and changing really the meaning of citizenship in the United States, especially in the federalist framework that we have. And I also say that this is an important clause because it is the source of birthright citizenship in the United States. The principle that if you're born here, with certain exceptions, certain limited exceptions, if you're born here, you're automatically a citizen here. And the prevailing Supreme Court precedent comes from the United States, Wong versus Won Kim Ark. And as a brief overview of this case, essentially what happened is Won Kim Ark was born in the United States, and his parents were Chinese citizens, but were legal residents at the time. And so later in life, 21-year-old Won Kim Ark, after his parents had gone back to China, went and visited them. And then when he tried to re-enter the United States, he was denied re-entry. Okay, on the premise that he wasn't he wasn't a citizen. And so in a nutshell, the decision from the Supreme Court said that everyone born on US soil is, quote, subject to the jurisdiction of the United States, pursuant to the citizenship clause of the 14th Amendment, with certain exceptions, like people are here that are foreign diplomats and soldiers. A short quote from the Supreme Court's opinion in this case. The Supreme Court said that this question is now settled by the 14th Amendment itself, that citizenship of the United States is the primary citizenship in this country, and that state citizenship is secondary and derivative, depending upon citizenship of the United States. The states have not now, if they ever had, any power to restrict their citizenship to any classes or persons. And so really, this is I think a really good expression of, following the 14th Amendment, how the citizenship clause really redirected and reoriented the nature of citizenship in the United States within our federalist state versus federal framework. And so today, this is the prevailing interpretation and precedent from the Supreme Court on the nature of birthright citizenship, that, again, with these few exceptions, if you're born in the United States, you're automatically a citizen. Now, one potential ambiguity here is this case didn't directly involve the children of illegal immigrants. And so I think many people believe that birthright citizenship extends even to the children of illegal immigrants. The Supreme Court has never really said anything, or hasn't really directly addressed this. Moving on, let's move on to the Privileges and Immunities Clause of the 14th Amendment. This is one that receives a lot of discussion, continues to pop up in Supreme Court cases that involve the 14th Amendment, usually in a dissenting or concurring opinion. But in a nutshell, the Privileges and Immunities Clause, no state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States, today essentially protects our fundamental rights of national citizenship. Really, it's got a very limited scope today. And that it really doesn't exist to protect citizen rights beyond these sorts of fundamental rights, such as voting and moving about states and habeas corpus, the right to challenge your imprisonment. And the reason why the scope of this clause is rather limited is from the seminal precedent in the slaughterhouse cases that from the US Supreme Court. Essentially what happened in the slaughterhouse cases is that these cases involved a slaughterhouse monopoly established by the local state government in New Orleans. And essentially what was going on at the time is, but before the state established before they established a state-run monopoly, many slaughterhouses were contributing to sanitation and public health problems in terms of like the waste and byproduct of business was running into the Mississippi River. And so in order to kind of clean up this situation, so to speak, literally, the state established a monopoly where only state certified businesses could operate as slaughterhouses in the city of New Orleans. Well, that left a lot of people out of business because if you didn't receive the certified license, if you weren't chosen by the state, then you had to close up your shop. And so a various collection of these slaughterhouse business owners challenged this state-run monopoly before the US Supreme Court. And in addition to using the Equal Protection Clause and the Due Process Clause, also sought to use the Privileges and Immunities Clause to make the claim that the state was infringing on their 14th Amendment constitutional rights. And so in a sense, the Supreme Court, and this is where we get the kind of limited scope of the Privileges and Immunities Clause, is the Supreme Court focused their decision on the meaning of the Privileges and Immunities Clause, while also kind of setting aside the Equal Protection Clause and Due Process Clause as basically not applying for various reasons. And what the Supreme Court said effectively, and this is the current meaning today, or at least the prevailing meaning and precedent from the Supreme Court, is that 14th Amendment principles and the Privileges and Immunities Clause in particular is rooted in national citizenship and not state citizenship. And so therefore did not protect these business owners from actions by the state because they didn't involve rights of national citizenship. So as part of the Supreme Court opinion says, it is a little remarkable if this clause was intended as a protection to the citizen of a state against the legislative power of his own state, that the word citizen of the state should be left out when it is so carefully used. In other words, if you go back to the Privileges and Immunities Clause, which says no state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States, essentially the Supreme Court takes a very limited view of the Privileges and Immunities Clause as, look, this only involves or protects citizens against state governmental actions that would infringe on your citizenship rights that are national in nature. And that's not what was going on here. So the punchline here is that the Privileges and Immunities Clause doesn't really extend to all commercial activity, only to fundamental rights of national citizenship, like voting or moving about states and habeas corpus and that sort of thing. If we move on to the third and fourth clauses of the 14th Amendment, and these are the ones that have received the most activity and arguably in contemporary politics, especially since the 20th century, have been the most important clauses of the 14th Amendment in terms of ensuring constitutional rights and defining the scope of constitutional rights. So next, let's talk about the Due Process Clause. Nor shall any state deprive any person of life, liberty, or property without due process of law. Now, this is important for many reasons, but I would argue the most important reason is it has been the primary vehicle for so-called selective incorporation of civil liberties over time. So in other words, as I mentioned earlier, the civil liberties and the Bill of Rights were only intended to protect citizens initially against the national government. And that's rooted in the history of the colonists and their fear of centralized authority and how they were used to home rule, decentralized governments. And so they weren't really worried about what their states would do to them. They were worried about what the national government would do to them. And that under the Constitution, they were centralizing more authority in this national government that didn't exist under the Articles of Confederation at the time. And so they were worried about placing checks on that national government. So that was always the intent of the Bill of Rights. And this survived for a very long time until the 14th Amendment gives a certain set of Supreme Court justices a means to basically absorb the Bill of Rights and extend those protections, those individual protections, to protect citizens against states in addition to the federal government. And so a couple examples, Mapp v. Ohio is the famous seminal case that incorporated the Fourth Amendment right to lawful search and seizure, or the exclusionary rule, the principle that evidence collected in an unlawful manner should be excluded in a court. And in the context of a criminal trial, a Gideon v. Wainwright involving the Sixth Amendment right to counsel for indigent defendants is another important hallmark of the Due Process Clause here, and certain criminal procedural rights. I also note here that Lochner v. New York is a famous case. It's no longer live law, so to speak. But there was a period of time where the Due Process Clause of the 14th Amendment was interpreted quite differently and was used by the Supreme Court to defer to business interests in a way that it doesn't today. And in particular, just to add a footnote here, in terms of the Lochner era of the Supreme Court, as it's often referred to, was a period of time where the Supreme Court was not allowing states to pass certain labor protections for workers and that sort of thing. If we move to number 4 and the Equal Protection Clause, obviously this is another important key clause of the 14th Amendment today in the American political system. The language says, nor deny to any person within its jurisdiction the equal protection of the laws. So a little bit of context here in a few important cases where the Equal Protection Clause is central. The Equal Protection Clause was really included in the 14th Amendment to try to counteract the so-called black codes at the time, or state actions that existed to try to undermine the rights of Blacks. And so we can see that the Equal Protection Clause taking on greater meaning throughout American history, because although it was enacted with the aim of ensuring the national citizenship rights of former slaves, it has taken on greater importance as more debates and conflicts over the rights of different classes and groups of people have emerged in American politics. So of course, in Brown versus the Board of Education, you can't cite the Equal Protection Clause and talk about Supreme Court cases or notable Supreme Court cases without talking about Brown versus the Board. Used the 14th Amendment Equal Protection Clause in part to strike segregation and the separate but equal doctrine from Plessy. But there are others that we could point to, and this obviously is not an exhaustive list, nor was a list on due process exhaustive, but I'll just highlight Loving v. Virginia, which struck down a state prohibition on interracial marriage. And then more recently, the debates over same-sex marriage in Obergefell v. Hodges, and how the Supreme Court used the Equal Protection Clause and the Due Process Clause to declare that states must license and recognize same-sex marriages in the United States today. So that's an overview of kind of the different clauses of the the different clauses of the 14th Amendment, and a little bit on their meaning and context. I want to talk a little bit about civil rights and equal protection today. I want to touch on some current issues and recent issues that in one way or another, to some degree, touch on the 14th Amendment, and then open the floor to questions so that we can chat a bit about the 14th Amendment given the time we have until noon today. So a little bit about, and this is a general overview here. It's actually can get pretty complicated when you look at Supreme Court case law and Supreme Court precedents, but in general, we can say civil rights and equal protection today. The Supreme Court has applied various standards. And the way to think about this is when is some government regulatory action or interest or law constitutional if it treats makes certain class or group-based distinctions. So really it's about the Supreme Court is regularly balancing the regulatory interests of the government, state governments, et cetera, versus citizen rights. And so these are kind of the really kind of standards that exist in a general sense that the Supreme Court uses to kind of decipher and make this balancing act work in the context of real cases and real disputes that come before it. So the idea here is that they apply different tests to different circumstances in determining when some governmental action that might arguably infringe on citizen rights is or is not constitutional. And so at the top here, I have strict scrutiny, which is viewed as the highest test, the highest bar to clear, so to speak. If the Supreme Court applies strict scrutiny, it means they're really scrutinizing some governmental action. And the default usually when they apply strict scrutiny is that some governmental action that makes some group-based distinction that may not treat these groups equally under the law, is that the default is inherently that it's not constitutional. Okay, and that there's got to be a really good reason to make certain class-based or group-based distinctions for it to be constitutional, and that it's got to be operationalized or tailored in what's called narrowly tailored in a narrow manner. So in the language of the Supreme Court, to pass the strict scrutiny test, the government has to have a compelling interest, a really, really good reason, and it's got to be really targeted, as precise as possible, and have as limited as possible side effects, so to speak. And so generally, the Supreme Court has applied this standard and this test to governmental actions and issues concerning race and ethnicity, fundamental rights, and that sort of thing. When you move down the ladder, there exists an intermediate scrutiny category that has been used most often in the context of gender or sex-based rights. Some people would call this heightened scrutiny. Some call it intermediate scrutiny. The idea here is the government still needs a really good reason in order to treat, for instance, different genders or sexes differently. But there's a little more leeway for the government to take action in this category when compared to something that falls under strict scrutiny or when the Supreme Court decides to apply strict scrutiny. And then lastly is the rational basis test, which just kind of encompasses more or less everything else, especially concerning the economic regulations and that sort of thing. And here, the presumption is that the governmental action is going to be constitutional, assuming there's some good purpose, there's some legitimate government objective. Okay, for instance, like, taxing certain classes of people more than others. It's easier for the government to take these actions in a constitutionally permissible manner if the Supreme Court applies the rational basis test. So this is like a one-slide overview. It gets really, it can get really complicated. The Supreme Court can apply these different standards, sometimes not in an entirely consistent manner. But these are some generalizations we can make about kind of weighing governmental actions versus citizen rights, especially under clauses like the Due Process Clause and the Equal Protection Clause of the 14th Amendment. So let's end today, before I take your questions, by talking, just going over some kind of important, or at least the salient political issues today and how they may touch on the 14th Amendment. Birthright citizenship is one. This was especially a salient, talked about topic in the context of the 2016 presidential election, and especially early on in Donald Trump's administration. And so, as we discussed earlier, birthright citizenship, pursuant to the Citizenship Clause of the 14th Amendment and U.S. v. Wong Kim Ark, has a pretty broad meaning today. Okay, but we could talk about what it might take to change it. Right? So, for instance, can a president change the meaning of this through an executive order or a legislative statute? For instance, if you go to Article 1, Section 8, it gives Congress kind of broad power to establish what's called a uniform rule of naturalization. And so, Congress has passed, for instance, the Immigration Nationality Act and delegated lots of decision-making authority to the executive branch. And so one might think that perhaps Congress can step in and alter that, but really you've got to change the meaning of that Supreme Court precedent, or you eventually, if you wanted to change the existing understanding of birthright citizenship, I think you're going to have to get a Supreme Court that's willing to change it and willing to deviate from the prevailing precedent in Wong Kim Ark. Next, we can talk about various issues of immigration, whether we're talking about amnesty or path to citizenships versus deportations. Obviously, these are really live issues in American politics and have been for a long time. All I will say now is immigration's not only a complex issue that involves, of course, executive branch decision-making, congressional decision-making, principally, but I'll just state that if we're talking about people who aren't naturalized or birthright citizens, strict scrutiny doesn't apply. So this is something where this is really incumbent on Congress to act, to take certain actions that affect immigration policy in the United States, again, with some understanding that the executive branch and the president already has the power to do certain things based on existing congressional laws that are already on the books. Certainly, there's been a lot of talk about voter ID laws, state election regulations. If you watch the news or anything related to politics for the last few weeks, of course, I'm confident you've heard talk about the recent Georgia law. The 14th Amendment isn't irrelevant to this debate, certainly, but also these sorts of issues more directly involve the 15th Amendment, the Voting Rights Act of 1965. I'll point you to a pending case that concerns certain state regulations in Arizona, Brinovich versus the DNC. The Supreme Court recently heard oral argument and the decision's pending. And then we can also point to, in the context of this debate, or should point to Article 1, Section 4 of the U.S. Constitution that says the times, places, and manner of holding elections for senators and representatives shall be prescribed in each state by the legislature thereof. but the Congress may at any time by law make or alter such regulations. So in a nutshell, 14th Amendment is, it's not unrelated to this debate, but this really more directly involves the 15th Amendment, the Voting Rights Act, and also Article 1, Section 4, essentially that if Congress doesn't take action to regulate elections, then states have the constitutional authority to pass their own laws, assuming they don't violate the principles of the 15th Amendment and to some degree the 14th Amendment and equal protection under the law. A few other issues we could talk about in kind of a summary fashion: affirmative action. 14th Amendment is central to affirmative action, whether we're talking about employment or government grants or higher education admissions, which continues to be a controversial a source of litigation in the federal courts. We talk about public education, diversity in busing in various ways, continued desegregation. Same-sex marriage and rights generally is certainly a hotbed, pertinent issue in American politics today, especially over the last 10 years or so. I mentioned Abergefell v. Hodges, the emerging conflict and kind of unsettled constitutional issue is, where do the rights of same-sex couples and gender-oriented sex orientation, how does that balance against the rights, individual liberties of others? And so the extent to which the individual liberties of others may conflict with the citizenship rights and the general rights and equal protection of same-sex couples, and is certainly just an unsettled conflict to a large extent. So it's something that I expect we'll continue to see the courts weighing in on. And then lastly, I should note that gerrymandering. For the 14th Amendment, gerrymandering, I should be clear, the strategic drawing of US House districts by state legislatures for certain political or otherwise purposes. The 14th Amendment and equal protection is central to racial or other types of gerrymandering, because gerrymandering and how the US districts for electing members of Congress and members of the US House, that is, how those districts, which are most of which are sub-portions or sub-regions of a state, how those districts are drawn is critical to representation in the United States today. So what we do know about racial gerrymandering and how the 14th Amendment Equal Protection Clause in particular would apply is the Supreme Court says there can't be any pro or anti-minority representation. You can't use this process of redistricting to suppress, for instance, minority representation. But as we've seen recently in Richo v. Common Cause, partisan gerrymandering is very much an issue that, it's alive and well today, suffice it to say. And it's very much an issue that has been percolating in the federal courts, and the Supreme Court recently came out in Richo and basically said it's non-justiciable. Meaning that the courts aren't an appropriate venue to deal with partisan gerrymandering, and in large part because the Supreme Court doesn't seem to think that they can come up with a workable standard for what constitutes excessive partisan gerrymandering that would violate rights under the Constitution. And then, of course, I should just note in passing a presidential election in 2000, which arguably is a one-off, but certainly involved the 14th Amendment in terms of standards for counting or disqualifying ballots. So to sum up, and then I will give the floor to all of you to ask any questions that you would like. To sum up, the 14th Amendment has really been a centerpiece of defining national citizenship, and it really was a key part of constitutional history in terms of reorienting citizenship rights in the United States. And I would argue it's probably taken on greater importance than the framers of that amendment even could have expected. And of course, is commonly the case because you can't always anticipate the types of issues that will emerge later in society. And so the 14th Amendment, though, has been a key cog in many debates over citizenship rights and equal treatment of various people in the United States under the law. And of course, the 14th Amendment has been critical to help bring more de facto citizenship and equality to minorities in the United States. So the Civil Rights Act of 1964 and the Voting Rights Act of 1965, and especially the Civil Rights Act of 1964, critically depend on the 14th Amendment and the principles that were codified there. And so as I note here, I have no doubt that it will continue to be an important clause in litigation and constitutional debates in society today. So let me stop there, and I'd be happy to take your questions. And perhaps I'll stop sharing and we can talk more.
Thank you. It's fascinating. Let's see if I don't see any questions in there right now, but if you have questions, you can just type them into the Q&A section and we'll be happy to respond to those. Well, here's one. How has the Supreme Court used the original understanding as a way of interpreting the 14th Amendment in some of the high profile cases, such as affirmative action and same-sex marriage? And that again is from Jonathan. I think we might have to introduce you to Jonathan.
Certainly. Well, we know that Supreme Court justices have different views on not only defining original intent, but whether or not they should even be applying original intent to successive cases in the future. So, I guess if you define the original intent of the 14th Amendment as to ensure citizenship rights for Blacks and former slaves, like that sort of original intent, the 14th Amendment has been used for purposes that have gone broader than that. And so, that's in large part due to expanding the application of the 14th Amendment. And depending on your view on originalism and original intent, you could be a departure from original intent in order to protect the rights, other types of rights and other means of ensuring equality under the law. So that's a deeper debate on originalism, how to define original intent, and among Supreme Court justices, whether or not they even think they should be looking to original intent when determining what the 14th Amendment and other clauses of the Constitution should mean at any particular point in time, and whether or not they should evolve with society. Thank you.
This one, I know you saw that one. Okay, good. Mm-hmm. So Patrick, I wondered, I was thinking about the title of your book, the first one, how do their personalities play into all of this?
Oh gosh. So, well, my co-authors and I, and this is an emerging emphasis in studies on the Supreme Court. I spent a lot of my time studying the U.S. Supreme Court from a political perspective, to be frank. Mm-hmm. So, there are lots of different traditions in studying public law and courts in the United States, and I focus mainly on the politics of it. And take less of a jurisprudential kind of legal view of things. So with that in mind, a lot of my research is interested in the human side of decision making and recognizing that Supreme Court justices are human beings. And so how can we think about regular things that we know, qualities of human beings, how that might affect the way in which they make decisions. And so this has led to a focus on personalities and how personalities may, we know justices are people, they have personalities, so thinking about how that might shape their decisions. And so in our book, we look at a number of different areas of the judicial process, of different actions that Supreme Court justices take, and try to assess and examine the extent to which personality affects those decisions. And I should be clear that scholarship on personality usually focuses a lot on what's called the big 5 traits. So there are different dimensions of personalities, and that people are more heavily weighted in certain dimensions or have different personality profiles. So what we focus on in our book in particular is the trait of conscientiousness. The fact that some people are more or less conscientious. which is in kind of research on personality and psychology, usually means more conscientious people are more rule-abiding, more thorough, more dutiful. They try to take initiatives to solve problems. These tend to be the qualities of more conscientious people. And so we focus our attention on conscientiousness because it's an important, in our view, personality trait when it comes to the practice of judging. That even if you go to the American Bar Association, when you look at the American ABA's description of what makes a good judge, we think conscientiousness is central to that the fact that you're really thorough and doing a good job, and you're rule abiding and you're dutiful. And so we examine a whole range of behaviors from the Supreme Court's agenda setting decisions to grant writs of certiorari and review cases or not, to the way in which they write opinions, to the way in which they vote, recusing themselves, deference to the Solicitor General. So we assess a range of things, a range of activities to show empirically how personality and conscientiousness in particular seems to affect, at least at the margins, if not to a large extent, the kind of decisions that they make. And so that's really the focus of that research in that book. And I'll give you one example off the top of my head of a result that we find is in the context of agenda setting on the US Supreme Court. We know that perhaps the principal factor that affects whether or not the Supreme Court reviews decisions of lower courts and agrees to a grant of writ of certiorari and review a case. Basically, most of the decisions that the Supreme Court makes today is because they have the discretionary authority to take a case and review it, and they have decided to do so. So what affects those decisions, what leads justices to want to do that, one big factor is lower court conflict. That in order to establish uniformity in the law, justices want to clear up issues and understandings of the Constitution and what have you, that where they see conflicts in the lower courts, where you have lower courts, various circuit courts in the United States making different decisions on roughly, or if not the exact same issue. And so they want to clear those up so that the law is more uniform. Well, we find that it's the conscientious justices, the more conscientious justices, that are more likely to vote to grant to review cases in order to clear up that conflict. And less conscientious justices are less likely to want to review those sorts of cases. So I'll stop there. I could talk about I could go on for another hour to talk about that, but I certainly appreciate the question, because it's certainly something I'm interested in. And I think it's an important kind of frontier in terms of scholarship on the US Supreme Court.
Yeah, it's such important decisions as we consider who those justices are. So it's fascinating. Maybe we'll have you come back and talk a lot more about that. That's, I think, a very interesting research that you've done. Okay, 2 more questions. Could the 14th Amendment stop Trump from being president again?
I've not heard that argument before. So I wouldn't expect that. I think, as we know from recent kind of political debates, the only way you could reasonably do that, other than through the actual selection process and not being nominated, was through the impeachment clause and Congress taking action to essentially declare that he's unfit for office and unfit for future office.
All right. The second is, what will be the outcome of lawsuits challenging the recent Georgia election laws?
You know, that's a really good question. And we'll learn soon. The Brnovich v. DNC ruling concerning Arizona laws, there are some parallels there. That case that's pending concerns 2 provisions in particular, one of which is called ballot harvesting, or prohibitions against ballot harvesting in Arizona. I should be specific, where in Arizona it makes it unlawful to collect absentee ballots and turn it in on one's behalf. And so that's one of the central provisions in that case that you can draw some parallels to the Georgia law. And so, I'll emphasize a couple things. Number one, the circumstances in different states and the specific details of different cases, they can be different. And so you can see different decisions on that basis. And we don't know how the Supreme Court is going to rule in the Arizona case that's pending until we actually see the ruling. But if you want to read the tea leaves, and I've reviewed the oral argument in that case, it seems like there's at least 5 justices to uphold those Arizona regulations on the basis that the Constitution gives states the authority to enact electoral laws, provided that the Congress doesn't take any action. And so then the question becomes, how overt, or what's the evidence to suggest that those laws are in some way suppressing votes or discriminatory in some fashion? And what is the bar for the evidence? I mean, how much evidence do you need? Is it just intent? Is intent plus effect? Other questions that come into play, and you'll see in kind of the oral argument that happened. Justice Gorsuch mentioned, is it permissible for states to anticipate issues that might happen in the interest of election integrity and protecting the fairness of elections? So there are lots of considerations, but I think if I had to guess right now, that this current Supreme Court is unlikely to strike down the Arizona law, and we'll see, but perhaps unlikely to strike down, if it gets to them, these provisions from Georgia, based on the current makeup of the court. I could be wrong, but that's my sense of things. And it becomes this kind of debate over states that want to take certain actions to protect the integrity and fairness of their elections versus the argument that certain provisions may be suppressing votes in various manners. And so it becomes a determination of how direct is the evidence to suggest that those provisions have actually or will likely suppress votes.
Thank you.
Thank you.
That ongoing dilemma and how long it will take before that really is resolved. And it's an interesting. Yes. Good. Any other questions? Any other comments that you'd like to share with us before we wrap up for today? All right. Well, Patrick, thank you so much. It's been so interesting and fascinating to listen to you. I'd love to have you back again and talk more about the dynamics behind these Supreme Court justices and the impact in our world. It's fascinating. But I appreciate so much your conversation with us today and you taking the time out to join us, and want to thank all of our guests for being here with us today too. So thank you. Have a great weekend, everyone.
Thank you, Lynn. Thank you, everyone. Have a good weekend.
Thanks.